Well, welcome everybody to both our audience here and to everybody online, including those of you who will log in later to watch it rather than live. My name is Edward Cowpe and my co-presenter is Aditi Rao.
Yep.
Aditi. And tonight's topic is referrals and joint expert conclaves, the ins and outs. And the idea here, before I go any further, I'd just like to do welcome to country. So we would like to begin by acknowledging and paying our respects to the Gadigal people or the Eora Nation, the traditional customs of the land on which we are conducting this CPD. So, but just basically the idea to this evening, we'll go for about 45 minutes. We'll give you an overview of both these types of processes, referrals and joint expert conclaves. And you're free to bob in any time with any questions and we can deal with them on the fly. There's also an opportunity to ask questions at the end if that's preferred. So let's start off with what are they? So I'm going to deal mainly with the referrals and Aditi will deal with the joint expert conclaves. And there'll be a little bit of interaction to begin with and then we'll deal with referrals by itself and then we'll finish off with joint expert conclaves. So what are they? So a referral is where the court refers specific issues in dispute in a proceeding to a referee for inquiry and report to assist in the resolution of the proceeding. The court can in fact refer the whole of the proceeding, but usually is confined to defined questions. I think the referral of the whole of a proceeding would be quite uncommon. Aditi, you want to talk about the next one?
Yeah, joint expert conclaves happen in more of a traditional adversarial setting. So usually the parties have their own retained experts who are expert witnesses, and then they're usually ordered by the court to meet with each other and have a comprehensive discussion, produce a joint report, which sets out basically the focus is what do you agree on, matters that are agreed, matters that are not agreed, and reasons for disagreement. And court can, but doesn't have to, appoint an independent facilitator for non-legally trained conclaves to help them
to assist.
Write reports.
That's right. And we'll go into the detail of how they can make that contribution a bit later. Welcome.
That's right.
But the important thing to note about both referrals and joint expert conclaves is that the ultimate determination of all issues in dispute always remains with the court. It's a process to assist the court in the resolution of the proceedings. As per the digital process, the court always makes the ultimate determination. So the next issue is, well, why do these things? Basically, at its most basic, it promotes the civil justice overarching purpose of the quick, inexpensive and efficient resolution of a proceeding. Now that's been the basic issue now for some decades. So with referrals, essentially some issues are better handled by a referee than a court. And we'll come on to some examples in a moment. But basically, whether to refer some issue to a referee is a case management decision informed by the overarching purpose. And there's this case, Kadam and My Resorts, in front of Mr. Justice Lee back in 2017. And to anyone looking at referrals for the first time, it would pay very much to read that judgment, at least the first 20 pages or so, because His Honour gives a very good background of the history of referrals and what they've been doing in the UK and Australia and the process as well. So it's actually a very good primer, if you like. So they're typically used where, for example, there are technical or scientific facts that need to be examined, particularly things like engineering cases. A prolonged examination of voluminous documents or accounts is required. A lengthy investigation would be inconvenient or delay proceedings. And when it comes to expert conclaves, Aditi?
Yeah, look, I think you do them for, I see two ways to think about the reasons. There are two reasons. One is the long-standing concern about the independence of experts. There's been discussion for many years, especially in the last century, of those experts who are hired guns, and they're described in quite critical terms by various judges. And expert conclaves are one of a suite of measures that can be used to take the experts and their evidence out of that really adversarial bias situation, because what you're doing is forcing experts to sit across the table from another person who is fully qualified in the same field, and can to some extent hold them accountable face to face. So that's one of them. And the other way to think about it is to identify the real issues in dispute in the expert evidence. There are quite often false issues that come up in the course of experts writing a report and then criticising the opponent's report in some identified respect, and then it gets to something in reply, but then face to face, the experts are able to treat it, to put it in perspective, and it can have quite a simple resolution, and it becomes a sort of a footnote in the case, whereas an issue like of that kind, if it were left to trial, might end up occupying hours of cross-examination and might effectively distract everyone from what is the ultimate issue. So you can knock those out of the way and narrow the issues in dispute before the final hearing. The joint report can also serve a couple of really important functions in helping the judge write the judgment. One, it can give a primer on the subject matter that is something that the expert subject matter that's, by definition, outside the judge's expertise. And two, it gives the judge a sort of a pathway through the issues. I've said it maps decision pathways through the expert issues, and concisely expresses the competing expert reasoning within the logic of the expertise, the area of expertise, which is a way of getting the judge up to speed on something that might be quite foreign, unfamiliar.
Okay,
So
thank you, Aditi. So here's some examples. So for example, in terms of references, there's many examples. They're actually very, very flexible and can be used in all manner of ways. Investigation of damage to insured premises, ownership and costs of reinstatement. That was back in 1989. Questions of design and construction of a building. Complicated trust account issues. Scientific and engineering issues. A much more recent one is the complex foreign law issues, which was the Cowpe case itself. I mean, just very basically, in that case, there was a class action and there were two proceedings commenced in the Federal Court of Australia, and they were being case managed together. And one of the parties, it was challenged whether they had the entitlement to be a party to the proceedings, and that was basically governed by Indian domestic law, and it was quite complex. And Mr. Justice Lee, over the objections of the parties, appointed a referee to decide whether or not, under Indian domestic law, this party had standing. And in fact, he mentioned a number of factors he took into account, but one of them which stuck in my mind was he wanted to avoid two retired Chief Justices of the Supreme Court of India from having to give evidence and be cross-examined, which he thought would be a bit unseemly. There were many other reasons about that.
I think you should have done it. That would have been exciting.
No, that would have been quite complex. Another quick example, a reference for tender and appointment of a class administrator and a class action, which Aditi will talk more about. Another one which is quite extensive was a reference to devise the optimum methodology, search criteria and parameters to be applied to a non-active party's extensive document repositories for the purpose of discovery in accordance with the overarching purpose, because that case involved something like 40 different databases, more than 28 million documents. The party that had control of the documents was in winding up and didn't want to spend any money, but the other parties wanted to see what they had. And so that reference was, well, how do we better manage the review of more than 28 million documents to work out what was relevant or not. So that was a good example of a reference. And when it comes to expert conclaves,
Yeah, I just thought I would add a footnote to that. You mentioned the scheme administrator references. Those are interesting, and I'd say it shows you the breadth of the potential uses of the reference process, because the cases that you've listed there on the slide, Edward, are what you might think of as traditional fact-finding references. What actually happened. You get to the scientific truth or the accounting truth.
Yes.
And to work out what has happened as a matter of fact. But the scheme administrator references are in the nature of asking the referee to read a number of schemes and a number of tenders, evaluate them, and come up with a recommendation for who should administer the scheme. And sometimes they also have to recommend which scheme should be chosen. And I know that
by the court.
Yeah, that's right. And so that's not a fact-finding exercise, really. That's an evaluative.
It's an evaluative decision, quite right.
Yeah, and it's of quite a different nature.
Well, the one that I was involved in fact, we had to draft a tender protocol and publish it on a website to say the court has called for tenders. It was court order. The court's called for tenders to be the class administrator of a multi-hundred-million-dollar settlement. And we put up a protocol, put it on the website, and then they put in their tenders, which were then evaluated, and they were asking questions, and documents and information was required. And then a recommendation was made to the court via the report. The inquiry was which tender was the best tender. And the report was made, and then the court, the parties obviously got an opportunity to comment on that, and the court then made a decision by selecting a class administrator. So a lot of that, drafting a tender protocol, for example, is not what we would call fact finding. Okay, so general pros and cons, very flexible, no one size fits all. I think we've tried to demonstrate that. The basic idea reduces demand on judicial resources. In that discovery methodology reference I talked about, I was the referee in that matter, and I received close to 4,000 emails in that matter, and the parties, through their lawyers, have made numerous submissions about what should be discovered, what shouldn't be discovered, what's relevant, what's not relevant, what's reasonable, what's not reasonable. And, those queries have been dealt with on a daily basis, and you just couldn't possibly have gone to the court to try and get all those discovery little skirmishes sorted out once a month. You just couldn't have done it. There's a question of whether it subverts or is inconsistent with the judicial process. You'll see later on that basically the courts say that it doesn't subvert and is not inconsistent with the judicial process. You're not entitled to have a judge deal with every single issue that comes up. There's obviously projected time and cost efficiencies, but these can be wasted if the referee's report is not ultimately adopted by the court. And sometimes that happens, at least in part. Aditi, on the conclaves.
Yeah, well, as we've got in the slide, it's the same problem. If you have a conclave, then you're not cheap. If the joint report doesn't do what it's supposed to do, doesn't do what it says on the tin, which is identify the areas of agreement, disagreement, and give reasons. If it simply repeats, and this has happened, just tends to repeat the evidence in chief of the competing witnesses, they never really engage with each other, then it's almost entirely wasted. It's unhelpful to the judge and can be...
Yeah. Okay, so now because we're all lawyers, we want to be sure we've got power to appoint or order. So for referees, I'll just quickly run through these, Aditi. The federal legislation is mainly Section 54 of the Federal Court Act, and the referee rules, which are quite specific, are in Division 28.6. And in New South Wales, it's in the UCPR Part 20. And facilitators, they're more in their expert practice notes, including, the harmonised expert witness code of conduct. And they are mentioned in UCPR Part 31, Rules 31.2 and 24 to 26, and a practice note, joint conferences of expert witnesses.
Yeah, they usually come up at the level of rules. They don't obviously need direct legislation to authorise them as you would for a referee.
All right, just keeping an eye on the time. So just moving on to referrals and referees. We've just said undoubted power to appoint. A referral may be made at any stage in the proceeding. The court can appoint any person as a referee. Obviously, it's got to be someone with the necessary skills and expertise. The referee is not an officer of the court. Now, obviously, if the referee is a solicitor or counsel, they are by dint of holding that office, but not by dint of being a referee. But under the Federal Court Act, Section 54B says the referee has the same protection and immunity as a judge. Interestingly, there's nothing specific that I could find in the New South Wales system, but there is a common law principle that a referee enjoys a common law immunity from suit in the absence of actual bias, fraud or deliberate wrongdoing. The court can appoint 2 or more referees, and then both the FCR and the UCPR contain rules for deciding how the decision should be made in the event there's a disagreement between the referees. Importantly, the court can appoint a referee without consent of the parties and despite the preference of the parties. And Kadam is a very good example of that, because the parties were very opposed to a referee, but the court went ahead and did it anyway. And there's other cases which make that point clear. Now, there was some initial reluctance on the part of some judges to say, well, you know, really this is a judicial function, so we should be doing it. But I think Mr. Justice Lee has pointed out that that sort of reluctance has now moved on. It's been rejected. Interesting, in New South Wales, that is subject expressly to the right to trial by jury. So the important thing to remember is that there's no universal right to have a court or judge determine all matters in dispute between the litigants. That super case, 1992, Chief Justice Gleeson is regarded as a decision which puts it beyond all doubt, and has been since endorsed in other decisions. A party's opposition is a factor the court takes into account in exercising the discretion whether to refer, and the court will act cautiously. In New South Wales, under UCPR 20.13, any question or issue, whether a fact or law or both, can be referred, whether raised by the pleadings, agreement between the parties or otherwise. It's almost certainly the same in federal jurisdiction. They don't quite define a question like that. Of course, the referee is always subject to the supervision and directions of the court, and the referee's report has no binding legal force unless and until it's adopted by the court. So this initial setup, the parties are usually given an opportunity to nominate the referee, otherwise the court will appoint a person in default of agreement. You can't assume there will be agreement as to the identity of the referee. Sometimes the court appoints a counsel assisting if the referee is a scientific expert. The scope and conduct of reference is subject to the basic notions of fairness and natural justice. The terms of reference are set by the court orders guided by the FCR or the UCPR. Supplementary orders are often made, and the terms are quite comprehensive. There's a requirement under both jurisdictions to provide what's called an initial brief statement provided by the parties to the referee. That's a vitally important document. It sets out the factual background, a summary of the factual and legal issues in dispute, and the contentions of each party. I mean, sometimes these cases have been going for a couple of years if they're really large actions. And sometimes the pleadings are quite voluminous, and you can't just hand a whole pile of pleadings and previous court orders and hope the referee gets on the top of it. So the initial brief is a very important document to help get the referee up to speed. Like I say, the copies of court orders and pleadings are provided, but they can be very substantial. In one reference I'm involved in, I kid you not, there's 10 cases being case managed together in a federal court as we speak, and I think the pleadings already exceed 10,000 pages of all the cases involved, not just one case, all 10 cases. And I think that's beyond the wit of anybody to try and get on top of more than 10,000 pages of pleadings.
Similar cases.
Yes, they're all got common facts, common issues, but nonetheless, they weren't commenced as a class action. They're 10 separate cases being case managed together. You know, they have their own individual factual issues, but there are very many common issues, correct. The initial brief greatly assists the referee in getting on top of the case, understanding the claims being made, what questions must be addressed, and the context. Questions, usually orders are made that questions to the referee cannot be varied except by court order. And that is an issue because sometimes once you start to meet with the parties and their experts, you actually say, well, after a while, you say, well, actually, that's not the right question. A different question should be addressed, in which case you can obviously apply to the court and get directions to have the questions amended. I mean, the court doesn't want the referee to basically just say, well, you know what, forget all about this. This is what you really should be focusing on. That's not the referee's job. Usually get court sets a time for delivery of the report, consistent with trial scheduling orders. So the conduct of the reference. So the reference being set up, much depends on the subject matter of the referral, always subject to the directions by the court. The referee is to conduct the reference as he or she, subject to any directions by the court. The referee is to conduct the reference as he or she thinks fit. That's in the rules. But the referee is required to observe the requirements of natural justice, and in particular the essential requirements of procedural fairness and genuine and impartial evaluation. And there's cases about that. So the referee obviously needs to hear both sides, and you need to be consistent with the rules of fairness and genuine impartial evaluation. So the referee must give each party an opportunity to submit relevant matters and evidence and to comment on each other side's material and comment on contentious matters. The usual language now being used is usually commanded to conduct the reference as he or she considers will, without undue formality or delay, enable the reference to be carried out in a timely, expeditious and manageable manner so as to minimise the cost of the reference. And that is usually set out in orders as well, because the whole idea behind it is to be a time and cost-saving mechanism. But the exercise itself is comparatively informal compared to the judicial process. The referee and the parties can apply for directions at any time during the reference. If the parties become unhappy with the way the referee is conducting the reference, they're entitled to apply to the court for directions. They usually give you notice, and then the parties can make submissions to the court. There are wide powers to gather evidence, and generally the rules of evidence do not apply. I mean, these are set out in the rules itself, subject to those basic rules of natural justice. So, for example, no private conversations with any of the parties or witnesses. Probity is essential. So you set up a mechanism whereby there's an email group that's set up, and all the parties must, every time they communicate with the referee or put in submissions, must copy everybody in. So everyone is aware of that. So there's no private submissions, there's no private conversations. That would be problematic. Now, in conclaves, I mean, Aditi will come to this, sometimes an expert comes to the facilitator and says, oh, can we talk about this, this and other? And you have to say, well, actually, we've got to talk about this in open conclave. A referee is usually empowered to communicate with experts engaged by any of the parties and to make inquiries electronically, by telephone and writing. I say that the referee can even engage their own experts if need be. They're not stuck with the parties' experts. If the referee needs some assistance, particularly say with high tech, with coding, with IT, I've seen orders which says that the referee can engage those people.
At their cost.
At the party's cost, not the referee's cost. Yeah, the referee's cost, not the referee's cost. We'll come on to referee costs shortly, but that's a good question.
If that's recoverable with proceedings.
Well, I mean, the referee wouldn't go say, oh, by the way, people, I've engaged this engineer and he's helping me get this part done, and by the way, here's a bill for $100,000. It wouldn't happen like that. There'd be no unpleasant surprises. In fact, the referee would say, I'm proposing to engage this person. Now, obviously, the parties didn't like that. They apply to the court for directions. It's always within the control of the court. There's no unpleasant surprises.
There's a cost estimate for the court to consider.
Not always. I've done some matters where some cost estimates have been provided and others not. Sometimes interim cost reports are provided to the court to help keep it in control. But you can rely on the parties themselves to help you control costs, because they'll be putting in submissions about whether that step's necessary or this step's necessary. I'm just looking at the time. Each party is commanded to do all things required by the referee to enable the referee to form an opinion. Funnily enough, In New South Wales, it says to form a just opinion. I mean, that's just absolutely unnecessary adjective. I mean, I don't quite know. Is a party going to say, well, Your Honour, we didn't cooperate with the referee because we took the view he or she was forming not a just opinion. It's just silly language. And not to willfully do or cause to be done any act to delay or prevent the referee. Now, that's important, and usually that's reinforced by a court order. And it gives the referee enough power to say, well, I'm asking you to do this. This is the task, this is the time and delivery date that I want it by. And basically, the parties have to comply because that's what the court orders require. If they don't like what's happening, they can apply to the court. This provision is key. The referee will often call for documents or submissions from the parties on key issues, contentions, and will set deadlines for responses, which the parties must comply with. In the absence of it, it would be actually quite a waste of time. So the referee's report, the referee must give to the court a written report about the matter that has attached to it the initial brief statement. Now, I'm a bit wary about that. I've actually applied to the court to that part to be waived, because sometimes these initial brief statements can end up being like 200 pages long. And, you know, you're giving the court a 40-page or 50-page report with 200 pages of annexures to it. Sets out the referee's opinion and sets out the referee's reasons. The referee sends it to the judge's associate, who forwards it on to the solicitors. In federal jurisdiction, the court can adopt the report in whole or in part, vary the report or reject the report. New South Wales is a little bit more nuanced. The court may adopt, vary or reject the report in whole or in part, require an explanation by way of a further report from the referee, remit the whole for further consideration, and may decide any matter on evidence taken before the referee without additional evidence. My view is that the federal court could do the same thing. The court will hold an adoption hearing where the parties can make their submissions as to whether the report should be adopted or rejected in whole or in part. They're not always adopted in whole, they're not always rejected in whole. Of course, the stance of the parties will depend in part on the outcome of the report and whether it favours a party's claims or defences. Submissions can extend to issues such as the referee going beyond the terms of reference, not addressing or misunderstanding the defined questions, misapprehension of the evidence, not providing a sufficient reasons, and perhaps bias. Ultimately, acceptance or rejection is a matter for the court to decide. What's involved is judicial discretion to be exercised consistent with both the object and purpose of the rules. Importantly, the parties are not allowed to relitigate the matters dealt with in the report. The right to be heard does not involve the right to be heard twice. The very purpose of the report is to provide, where the interests of justice dictate, a form of partial resolution of disputes alternative to orthodox litigation, and would frustrate that purpose to allow the reference to be treated as some kind of warm-up for the real contest. And that's been around since 1992 and was endorsed by Mr. Justice Lee. Of course, if the referee report reveals some error of principle, absence or excess of jurisdiction, patent misapprehension of the evidence, or perversity or manifest unreasonableness in fact-finding, it will be ordinarily rejected. So it can miscarry, and it's up to the party to demonstrate that. The court's reluctant to allow factual issues to be determined, to be re-argued. They ordinarily will not revisit the referee's findings of facts where there's sufficient material to entitle the referee to make those findings, particularly where the parties have had an opportunity to make their submissions and it's a technical area of expertise. To do otherwise negates the value of making the reference, providing the reference to the referee. Following the adoption hearing, the court will give judgment or make an order in relation to the proceeding in question. The references can become multiple references. So in that discovery methodology report that I mentioned, there was the methodology report, which was the initial reference, which was adopted by the court. And then the court appointed the referee to then conduct that discovery exercise, which took 14 months by reference to a methodology report. So that was a second exercise for the referee. So just coming back to what was mentioned before, cost of references. Costs are always within the control and discretion of a court. You have to distinguish between the referee's costs and the party's costs. In New South Wales, the court is expressly empowered to determine the referee's fees, direct as to how, when and by whom such fees are to be payable, and determine the consequences of failure to comply. I'll just finish that off. So no equivalent express rule in federal jurisdiction, but there's ample power anyway. So the referee is appointed by the court, not the parties. So none of the parties are the referee's client. Referee does not need to enter any sort of cost agreement or engagement agreement with any party. But if you're a lawyer that's doing the job, best to provide your hourly rates and try to provide an estimate. But it's all under the control of the court. And depending on the length of the reference, court may order referees' fees to be paid by other parties in equal shares, pending the outcome in the case, in which case they're costs in the cause. So I know I went through that a bit fast, but I was just watching the time. So I'll just now hand over to Aditi on expert conclaves.
Thank you, Edward, for that pretty comprehensive account of.
Bit fast.
Well, they're comprehensive. I had a few thoughts during your presentation, and I don't want to delay everything, but I just wondered, and these are things people can think about, at what point does the referee become functus, for example, once they've submitted the report?
Essentially, yeah.
If they think they've made an error,
Well, I haven't come across
they
where
don't have the right to correct things in the way that
I think it's functus when basically the referee sends the report into the court and then does nothing pending the submissions by the parties about the adoption or rejection of the report. I mean, if the referee said, "Oh, you know what? I think I've made a fundamental mistake there," that referee could write to the party and seek directions.
Yeah,
but it's basically
there's a
all
solution
over.
to that scenario. But I just wondered.
That's right.
What the issue, where the power, what happened to the power? Yeah. I guess I've got a few. Can I just?
Sure.
Yeah.
Sorry.
Slide that over. Yeah. I've got a few expert conclave examples on this slide, and this is just to give you a flavour of how many of these cases are highly technical. They involve a lot of usually scientific evidence, and you've got 10 separate conclaves that occurred in each of the first two, McNichol, which is the glyphosate case, and Cowpe, the Ruby Princess trial. And they all had, but both of those had a facilitator. I guess the difference you see between the first and the second there is the number of experts per conclave. And if I have one message out of this, it'll be something I have to say about that. And the last one is X, Sydney Children's Hospital. That's not very recent, 2011, but that'll give you a flavour of the medical negligence type cases. You've got 10 medical experts in one single conclave. That's 10 experts in one conclave. And it's very common in these medical negligence cases. And they were given 18 questions to answer, some of which had separate parts to them. And initially they had no facilitator. And the document they initially produced gave one-word answers, despite the express injunction to set out the reasoning. And eventually a facilitator was appointed and a probably, infinitely superior report was produced at that point. So there is a sense you could say well, these experts are professionals
and
they're highly qualified experts, they understand their own field. Why do they need a facilitator to hold their hand? I understand that in principle, but in practice we just seem to see time and again that to produce something useful for the judge in anything of any complexity, you end up you want effectively junior counsel to assist with the expert evidence.
It helps enormously.
Now, what is it? What are we trying to do here? We want the experts to have a comprehensive discussion of the matters on which they've expressed opinions. They should be testing it. They can test each other's opinions, query, you say such and such, but what about, how do you deal with this? It's an in-person, in-depth, it's also online these days, but it's a close examination in a friendly format of the expert issues where they test each other. And usually, as I said, when you see a colleague face to face, the thing that's occupied a lot of attention or has become a very sharp criticism in the reports.
And the reports, yeah.
When they look at each other and look at that issue and say, oh, well, you know, I mean, it was just a minor thing. I just wanted to say such and such. And it reduces its intensity back down to it being a sort of an incidental matter. Whether that's a good thing or not, some people might say not, the tendency to resolve those things, but I think the judges obviously, that's exactly what they want these experts to be doing. They're very flexible, similarly to the reference process. The judges, it's really a matter of judicial preference, because the trial judge is going to be using these joint reports. And what you want to do is produce something that judge will find useful. Now, it's not meant to be sort of determined by pure individual preference. There's obviously some objective element there, but it's helpful to know what the judge desires. And I've given reference there to the Joint Expert Conclave Protocol, again, of Mr. Justice Lee, which is, I think, something his honour issues whenever he orders one of these conclaves.
Correct, yeah.
And it basically tells the experts, it's effectively, you know, written to brief the experts
and the parties.
And the parties. But, you know, this is what I want out of this. I want the experts to have a comprehensive discussion and try to agree, and where they can't agree, try to express the disagreement. As I said, the participants are conventionally retained expert witnesses. I mentioned parties and representatives are usually excluded from the conclave. I don't think I've seen one where they were allowed in, ever.
No, never.
The sanctity of the conclave, it seems to be an integral part, at least, of the ones we've been seeing lately. But in theory, the court could allow their attendance. I can't think of a scenario where you might want that, but I'd be interested to know if anyone in the room or out there has come across that and what sort of circumstances that might have occurred. As I mentioned, they frequently appoint a facilitator. They typically happen in the lead up to final hearing under a lot of time pressure. People are stressed and to try to get everything ready for a hearing. And it's usually, sorry, fine.
Yep.
Yeah. Oh no, I think I'm still on this one. I'm still on the first dot point.
I'm
trying to keep a pace with you, Edward. But you set a cracking pace.
Sorry.
Almost always they've done their evidence in chief of both sides or multiple sides and reply before it happens. So you've got a sense of what their starting positions are, and then they get put in a room to try and sort it out between themselves. In theory, as I said there, both the federal court rules and the UCPR expressly contemplate that you could order the conclave before they've written their individual reports. Again, I don't think I've ever seen that. No. I'd be interested if anyone has done that or seen that. Do let us know. And it often goes hand in hand with concurrent evidence in the witness box, as occurred in McNichol. And because we talked about immunity for referees, I thought I'd just pop in a expert witnesses immunity from suit. Probably applies to conduct in relation to the court-ordered conclave, because it has that intimate connection to the proceeding and obviously a direct ability to affect the outcome. I've got my typical orders. These, I probably won't go through all of these in a lot of detail, but we'll flag second dot point. There's usually a statement of specific questions if warranted. And those questions are put to the experts to answer. And they are in addition to or on top of the let's have you meet your meeting of minds on each issue. In addition to that, we want you to answer some specific questions. They'll pair up the conclaves, facilitator appointment, and orders for commencement and when the blackout starts, that parties and solicitors can't talk to their experts. There's usually an ability for the conclave participants or one of them to put their hand up and ask for help from the court. This is going awry. Something's gone horribly wrong here, or I don't know what's happening. I need the judge to look at this, usually through the facilitator. And then some judges will have a content-informed requirement. They'll remind you the usual criteria for expert reports, which is identify your assumptions as distinct from facts, findings, and identify your opinions, link it back to your specialised area of specialised knowledge, and all those things that we're all familiar with from Makita and DAS-REEF. Another thing is the protocol for use of what happens, what transpires during those conclaves. There's usually emails, maybe hundreds of emails back and forth between experts with drafts of the joint report. I think the default position in the Supreme Court is you don't go behind the joint report. You can't adduce any of that into evidence without leave. But I've seen express provisions to the effect that nothing is confidential after the conclusion of the conclave. Up to the conclave, no contact. Afterwards, you share whatever you want with your instructing solicitors. You can be told to confer generally specified issues like liability, quantum, or answer specific questions, which is, again, a further step of refinement. These may differ from the questions that were put to the expert witnesses in their primary reports. And that can sometimes present difficulty because if the experts have answered slightly different questions, usually there's a reason why the solicitors have chosen to do that. And you'll end up in a situation where an expert might say, well, that goes outside the scope of my report. And I have some sympathy for that point of view. But on the other hand, if the parties have agreed on the format of the questions and they want the experts to answer them, you're probably stuck with it. As I've said probably a few times now, the core content, content of a joint report is for each subject matter, what's agreed, what's not agreed, and reasons. The issue of scope is something that I think is of interest for me coming across these from time to time. I've got Justice Beach-Jones, as he then was, a quotation in that slide, and His Honour said, as a general proposition, if an expert expresses an opinion on a particular point, they should be in the conclave that addresses that issue. That makes sort of logical sense. That seems intuitively obvious. And likewise, if they didn't say anything about it in their report, they shouldn't be required to join that conclave, and probably they shouldn't be in it. But sometimes you do see experts brought into a conclave where they haven't expressly addressed something, but then they're given the opportunity to address it from the perspective of their expertise. I found this second quotation very helpful as a guidance. Again, it's all subject to what the parties want in each individual case, but the drafting of the questions can be problematic, and what His Honour says there is there to form, those questions form an agenda to guide the experts in their conferring. So they need to be at a sufficiently high level of generality that they do not unduly restrain the experts from the comprehensive discussion of the points of agreement and disagreement. No loaded questions, please. And it's not an opportunity to put new questions to the experts which do not properly arise out of or relate to the opinions that they've expressed in their reports. That's a suggestion of in general terms, a reasonable outer limit of where you should go. But then again, I've seen people go well beyond that. No, I don't know whether, I don't know whether they deliberately choose to do that or whether it's just the thinking about the case has evolved as the case has evolved, and so the questions are a little bit different. Yeah. The joint report itself, it has that core content, as I said in the first dot point. Often the judges will say it can take whatever form commends itself to you, experts. I'm not going to be prescriptive about it. So you can see narratives. A lot of academics will write narrative reports akin to a paper. Then I've seen experts in, say, aircraft maintenance engineering, for example, who do a table of issues, short form answers, agree, disagree, and then short form reasons. I disagree because of such and such, and it starts to look like a table of objections, shorthand, but it identifies the reason clearly enough, and those are often very helpful. Sometimes some of those are the best you can see because it's obvious on the face of it what the reason for disagreement is. There are the rules of evidence still apply in general to the joint reports. There's a sort of a subtle difference in the UCPR that it seems to dispense, at least in part, with the requirement for background and reasoning in the use of points, the joint report as evidence of points of agreement, because you don't need to give reasons for points of agreement.
That's right.
In practice, it all boils down to something quite similar. You're not going to get the judge to throw the laws of evidence into the bin unless the parties agree to it. And agreement on an issue, not automatically binding, but if your experts agree on something, well, it's a little bit like a concession during cross-examination. It's almost binding. Those concessions, if they were to be withdrawn, would need to be explained convincingly, and there would obviously be forensic significance attached to a change in position. Typical objections will be the usual expert ones. Outside expertise, actually legitimately outside somebody's expertise. You, sir, as an engineer, can't express an opinion about something adjacent to engineering, environmental science, maybe. Discretionary exclusions. Now, that has been alluded to multiple times, including in the bare scope case, as a potential basis for excluding a report. It's, I guess, there are various ways in which a report has miscarried so badly that its admission might be unfairly prejudicial. And then the other major problem, of course, is just non-compliance with the orders. You just don't do what you're asked to do. Facilitator's role, well, it's probably self-evident, but your job as a facilitator is to explain context, purpose, objectives, all the admin, timeframes, how to contact, how each participant is to communicate with the others. During the discussions, during the meetings, there's a role in helping them to remain focused on the real issues, and tasks, managing conflict, managing personalities can sometimes be a very significant part of the job for obvious reasons. And then it's your classic junior counsel role. It may be a bit more than your classic junior counsel role, which is to help the expert to look at the report through the lens of admissibility. Does it stack up? And help them where it doesn't, help them to redraft that material. And that it might be a slightly greater editorial role than counsel would have in an ordinary expert witness report. But obviously it really goes without saying the facilitator has no personal opinion, must avoid any insertion of their own personal opinions or any kind of interference with the merits, the substance of the joint report. They've got to be a completely neutral agent of the court in that situation. Document management is actually a surprisingly big headache for these. When you have different systems, track changes from multiple experts, it's pretty manageable where you've just got 2 experts in a conclave. And your facilitator might, in an appropriate case, create or provide a template for the report just to tell the experts, well, this is how you, if you're feeling a bit at sea, here's something to work with. It's not bound, yeah, that's right, a structure. It's not binding on you, but have a go, see what you think, adapt it as you see fit. So what does it look like in practice? Well, you have that plenary session meeting in the beginning where you explain all that stuff. If there's multiple conclaves, like the 10 conclaves that we saw in some of my examples, you might have all of the participants in that plenary to discuss the basics, the ground rules. Then you just have your meetings and discussions between experts. I think up to 2 hours, they can have concentration for up to 2 hours at a go, is my general observation, usually a bit less than 2 hours. And then it's time for a break, go off and do your writing, exchange drafts, and if needed, reconvene for another discussion. And that happens, repeat as necessary until you reach equilibrium. Within reasonable limits, I say. And that will come up in some of the pitfalls, I guess. The benefits, I think I've identified what I see as the benefits. You can increase the judge's confidence and trust of the expert evidence when you've got something that is produced by both experts and they've been taken away from their the context that usually supports an adversarial bias in reports. They can, again, just neutralise a lot of the small issues that would otherwise take up loads of housekeeping time or cross-examination at trial. As I've said, supports independence and gives the judge the cliff notes. I mean, it's much better than cliff notes. I mean, no disrespect by using that, but the brief, this is how you deal with this, and equips the judge to make decisions on matters that are, as I said, by definition, outside of their natural expertise. There are all of the usual risks and pitfalls, distorting factors. I've sort of split them into sort of themes. I've talked about distorting factors. So there can be, sometimes you get a sense of the experts have been told they must try to agree as much as possible, and they begin to trade concessions, which is not what that's supposed to mean. Try to agree as much as possible means still honestly and correctly in accordance with your opinion on your your question. It's not a case of if I compromise on this, you'll compromise on that.
Definitely not. Yeah.
And that's sometimes not understood. And there's a very natural human tendency to do that, I think. Then you can have a professional or power gradient between experts who are in the same room, in the same profession, very senior doctor compared to a less senior one. Academics, you know, it happens in all professions, but academics and doctors are some classic ones. And that can have a subtle distorting effect on how they approach the content. Another one is where one expert does the writing up. For example, the primer section, they might subtly and no doubt unconsciously impart their own viewpoint into the text. The next point, I think, warrants its own high-level dot point, the infinite loop of rebuttals and surrebuttals. This happens a lot, especially with online conclaves. They've had a discussion at a high level, put something down in writing, and then swap, and the other expert will then have a response. They'll have a reply to what the first expert has put down in their reasons for disagreement. And it goes back and forth. You know, you're exchanging drafts and somebody wants to say something else. And that the facilitator has a job bringing those infinite loops to an end. But you have to do it fairly. So that can be a bit tricky because you don't want to be the person who says to one expert, sorry, this guy's put in his riposte to your most recent thing, but I'm not going to let you put in your riposte to his.
It's last wordism, right?
Last wordism, that's right.
Wordism. It's an issue that does need to be managed.
What I generally try to do is find what I call the equilibrium point, where you get finally to a point where they say, oh, well, this is my perspective on this, that's my perspective on that. We just take different views about that. And once you get to that point, that's the natural kind of end point. Sometimes it's a lot of work to get there and you just don't have the time. You just don't have the time to do it. And yeah, all of these conclaves have to be proportionate to the time available. Sorry. Admissibility issues, I've covered those. Those are classic pitfalls. A facilitator should be a good solution, an antidote to problems of admissibility. Similarly, the loss of focus or non-compliance with orders, a facilitator should generally be able to talk people around to focusing on the issue, reminding them, look, you don't have to, sometimes it's just an argument, I'm right and you're wrong, and they never get to pick up the pen. And at that point, the facilitator's job is to say, okay, you don't have to agree. Sometimes you just state a point of disagreement and give your reasons and move on.
That's
right. Problems with what I call the constitution of the conclave. Too many experts in one conclave, and the complexity increases, I don't know, mathematically if it's a square relation, but it's certainly non-linear. Every expert you add to a conclave increases the number of cross comments and feedback and a dialogue. Now, I know in practice, if you're going to be, probably 2 or 3 of these are retained by the same party, the applicant, 2 or 3 are retained by the respondent, but it doesn't mean that they all have the same perspective. Sometimes they do want to comment on each other. So you have experts, each expert being entitled to comment on the reasons for disagreement of each other expert. You can see how that proliferates out of control. And that's why my recommendation, my takeaway would be keep it to 2 experts per conclave. 3 if you have to, but really it's 2 because that's the nature of the dialogue that's going on here. Another problem can be experts having different areas of expertise. How am I time-wise?
Oh, we got that 1 minute.
Yeah.
We're just about there.
Yeah. Different areas of expertise. Well, the problem with this is usually they end up concluding that the reason for their difference of opinion is the fundamental difference between their areas of expertise. As an academic, I approach it in this way. As a field practitioner, I approach it in this way, and that's the reason for the disagreement, which I don't know whether it really helps the helps the judge to decide the case, to say, oh, it's just because we come from different professions, but that might be the best you can do. Questions, as I've said, I think questions are a bit of a pitfall. They should be, in general, what Justice Lemire said, an agenda or a guidance to the discussion. It shouldn't be the opportunity to ask really challenging, detailed, new expert questions that end up being brand new expert evidence, just right at the doorstep of the final hearing. I think that covers what I want to say.
Yes, thanks,
Yeah.
Aditi. That was also comprehensive. So I note the time, it's 6:45, so we've been going for an hour. Is there any immediate questions? Otherwise, I'm happy to let everyone go. Well, yes, go ahead, please, Mr. Justice Austin.
I found this very helpful to me, partly because I don't think when I was a judge for 11 years, I ever had any engagement in this. I've met experts from time to time,
Right.
up the sort of conclave that's here.
Yes.
And what I'm now wondering about is whether the scope of the referrals and conclave arrangements is sufficiently defined so that we know what it is an appropriate circumstance for using these procedures and what's not. I noticed Justice Michael Lee, who we all know, is active in dealing with these.
He is, yes.
Michael Lee is a friend of mine, but I don't feel very happy about him today because at 10:15 today he delivered the Star judgment,
Oh,
500 pages.
wow.
I foolishly agreed beforehand to make some comments about it for the purpose of a journalist, and I said I would do it at 4 o'clock.
Not 4 o'clock today.
That's why I look so red-eyed. But I just wonder what use might be made in that kind of case for some kind of expert referral. One thing in particular that I respectfully think Justice Lee might not quite have got right is the extent to which it would be appropriate for a judge to have some input onto the things that actually happen in practice in well-run companies before the judge makes a decision about what the board of directors and the executive should do if there's just too much paper coming into the
Right.
room,
Right.
and the directors say, oh, we can't deal with this. Now,
Information overload.
well, I happen to know that there is a lot of non-legal pronouncements about all of this and how to handle these sorts of things. And I wonder whether it might have been appropriate for the judge to find out what actually happens in life and how things are handled before he delivered his analysis of what should and
The
shouldn't
way
be done.
boardrooms work. I see, yes.
Do you think there's any scope for that sort of thing? And is there even any scope for expert input on disputed questions of law?
Well, not so much on that last bit. I suppose, you know, the culture and the system we've got over centuries is they're called solicitors, barristers and judges as the experts on the questions of law. I mean, certainly foreign questions of foreign law, absolutely. But I
It's a
can't,
myth to
I-
say
I
that
tend to
judges can be expert on everything.
Yeah.
oh, absolutely.
But I tend to think that might be naive, but I had always thought that the process of submissions, which allows reference to textbooks, limited authors, journal articles, is a form of that. It is a form of consulting.
Like Austin and Black.
Yeah, that's exactly right. What Austin and Black says on a subject is something that a judge will consult.
Yeah, and give weight
And that
to-
is a form of, that's a
But
form of,
that doesn't attract all these rules.
no,
No, of course
No, it doesn't.
No.
that's a matter of law.
And what I'm saying is that there are some issues of law which actually require a factual input as well. And that's an area where there might be some non-lawyer expert that can
Interesting.
provide some help to the judge.
I'll call you tomorrow and we'll get a scope going on that.
And might that not be something that could be the subject of evidence adduced by one party at trial?
Well, that's another way to handle it, but the judge might want to have some expert input determined as a result of joint experts who have to talk about it.
Mm.
Well, thank you for that, Judge. That was very helpful. Well, I'm going to call this to a close now. So thanks everybody for your time and for being involved. It's all part of the process. Thanks so much.